Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. My name is Pam Esquire, also known as your law intellect. How are you all doing today? How are you all feeling? I hope you guys are doing fantastic. So fantastic that the first thing you want to do is hit that like button. Subscribe to the channel if you haven't done so already. And also, if you are new here, we would like to personally welcome you. And if you are in the bushes and you choose to participate in the chat, welcome you. Just be respectful. Everyone, please be respectful. You can give your opinions. That's what they are. However, we want you to be respectful to all parties involved. Thank you so very much. To all of you guys that have been rocking with me from day one or even recently, I appreciate all of your support. You guys know why we're here. You saw that title and you know why we are here. And so we have been covering Bishop tdjakes from over there at the Potter's house. Yep. He sued Duane Youngblood for defamation, and he's also alleging some form of civil conspiracy. And so for those of you that are unaware, what happened was Duane Youngblood one day said, I would like to tell my story. Okay. And in that story, he went over there to tell it on the Larry Reed live show with the host is Larry Reed Live. Okay. And he gets on there and he decides to tell about his upbringing and some of the trauma and tragedies that led to some of his issues that he had because he went to prison for SA as it pertained to young folks, okay? And in the midst of telling his story, he alleged that there was an incident of which he was the one that was assigned to transport then Elder Jakes around when he was in town to speak. And so they go over the lady's house of which he typically stays at, according to Youngblood. This is not me. I don't know these people, okay? So he says he goes over there to the lady's house and they're sitting at this table. And Youngblood felt like he was in a safe space after all of this trauma and tragedy he's endured. He was in this safe space to talk to Jakes about his life and some of the things that he had been through. And he was like, now this here is a man of God. And so when he said he had his mama's car and he said, oh, shucks, I've been sitting here. You know how you just talking to people and time slips away? He said time slipped away and he remembered he was still scared of his mama, okay? And so he had to get the lady her car back. So he said, I gotta go. So he gets up and he alleges that while he was trying to leave, I guess Jakes attempted to kiss him. That's what he's alleging. And he talked about this all of about 10 minutes. But because the other individuals that he alleged and talked about, nobody really knew who they were. Well, I ain't gonna say nobody, but A lot of us didn't know who they were. And so Jake's name just kind of, it was just highlighted. Even though it was a brief encounter, he did mention that he had other information, but he didn't go into that. And so allegedly he was going to do another part, okay? Because he did part 2. And then he was going to do a part 3, but that didn't happen. And what happened in between part 2 and part 3? Well, according to Youngblood, he alleges that there was a text message that came, or an inbox that he showed from Facebook that came from tdjakes' son. And he said that seemed like a threat. And so he contacted legal counsel, like, what recourse do you think I should take? And allegedly during this conversation, I guess he hired this attorney whose name is Tyrone Blackburn up out of New York. And Blackburn submitted a demand because apparently, I'm assuming, perhaps he was going to try to see if he had any litigation rights against Jakes. And so Blackburn sent a demand, and in the demand, I'm just from my, heavenly imagination, because I didn't see this demand, okay? Everybody's talking about the demand, but I ain't see it, you ain't see it, we ain't see it, nobody saw it, but these attorneys, all right? And perhaps Youngblood may have seen it, I assume. But I'm just imagining that in this document, because we as attorneys, we filed these. I told you about these documents that we filed demands in order to avoid protracted litigation if you feel like you can resolve it before litigation. Well, apparently he sets forth, I guess, facts of which he is alleging that Jakes had done. And so he said, well, for all of this, I'm going to need $6 million. This is what is alleged. And Jakes responded, I guess, with, I'm not going to give you anything but a lawsuit. All right. And so this happened on a Friday, allegedly. I believe that Sunday, Jakes was up there on the pulpit. And when he was, I don't know if it was around benediction time. I don't know what part of the service it was because I don't watch it. So I would be speculating. However, I, like many of you, saw Jakes on a stool. And while he was on the stool, he looked like he was having a medical emergency. And so everyone rushed to him because he looked like he might, tip to the left or tip to the right. And he looked like he was having a medical crisis. And so that was the big news all over. You had some people saying it was a minor medical issue. Then it was a life-threatening issue. Then I think it was when he came back on New Year's, he said he almost died. So you can call him Bishop Lazarus. Or he believed, I think, that he died or something of that nature. You can call him Bishop Lazarus. You know what I'm saying? Well, Bishop Lazarus apparently was already in talks with his lawyer. So while he was in there recovering, his attorneys were drafting a complaint. And that complaint was against Duane Youngblood and all these John Does, of which he believes is a part of an alleged conspiracy. And so, as you guys know, Blackburn is an attorney out of New York, and this case was filed in Pennsylvania, which would mean that if Blackburn wanted to participate in this lawsuit and continue to be his lawyer, he had to pro hoc vice. And in order for that to happen, you have to get local counsel. So when the time was nearing, okay, Richard Youngblood, who is Duane Youngblood's brother, he did a video and he started out basically saying, the caption, we thought he was about to say something in his video. So many of us watched to see what he had to say, right? And Richard Youngblood basically said that, his brother is ready to fight. He knows that he has this due next week and he's fighting this thing. Okay. That's what we got from Richard Youngblood. So we knew he wasn't planning on defaulting. He was going to be in this litigation. And so you guys keeping up with me? I know I get into my, narrative here, but I'm trying to let you guys know what happened before we get into this document. And so what ended up happening is a week before it was due, it being the response to the complaint. So Youngblood was served, all right? So before he was served, let me back up a little bit. So before he was served, apparently Jake's attorneys contacted Blackburn like, hey, can you accept service on behalf of him? And he was like, no, catch me if you can type thing. No, you're going to have to serve him directly. And so that same day that they said that, I guess when they was trying to get some type of service, their process service just went to the man's house, I guess, and they served him. And so he was served the lawsuit. So, of course, once the lawsuit was served, he had 21 days to respond. So this was back in November. And so what happened was Youngblood writes this letter to the court and says, Judge, Your Honor, the head and leader of this case, I need some time. All right. I need some time. I'm going to fight this with an anti-slap because what he is trying to do is quell and stop my freedom of speech, which is against the Constitution. And he threw in some case law, some Supreme Court case law in there. But then he also let the court know, oh, I have a viable claim. This is according to Youngblood. He said, I have a viable claim. And he threw some pictures of him as Youngblood, at a time of which Jakes was in the vicinity, I guess, to show a timeline that, yeah, I actually do know Jakes and I was around him. I ain't making this up type thing. And he said that he explained that the reason why he got an attorney in the first place was because he was threatened by one of the Jake sons and that he didn't know what to do. So he said, Your Honor, can I please have an extension because I need local counsel? All right? Because I don't have local counsel. In response to that letter, Jake's attorney responded and said, Your Honor, you should deny that extension. And you should actually make his response considered, his letter considered a response, which was like absurd to me to even ask that, but okay. And so they said, on behalf of Jakes, because, they're the representative of Jakes in this lawsuit. We don't think he needs an extension. He has an attorney. It's Blackburn. That's who his attorney is. And we assume that Blackburn is just having a difficult time finding local counsel because he had all these different issues with his representation. The court said that they were going to send him to the bar because they were alleging he was filing cases in the wrong jurisdiction, trying to get publicity over there in the Southern District of New York. So they attached that. Did a couple digs at Blackburn, was like, that's really the problem. You know what I'm saying? And it sounds like an attorney helped him write that letter. Well, within about an hour of that time, the court was like, yeah, we're going to grant your extension. Okay. We're going to grant your extension. So that was the first blow. They was trying to get him not to be able to get an extension. Okay. So that was the first blow. Then on the same day, 2 attorneys that were local entered their appearance. All right. So therefore, those local counsel, I thought maybe they were going to be his attorney, but apparently they were just local counsel so that they can sponsor Blackburn as he came into the jurisdiction of the Pennsylvania Western District Court. Okay, over there. So that was the second blow. I was like, whoa, okay. So then in the meantime, Jake's attorney filed a motion to expedite discovery. For those of you that don't know, In litigation, we talk about it a lot of times over here. Once a lawsuit is filed and the other side enters an appearance into the lawsuit and they respond, you have a conference of which you discuss different dates and how long you think the trial's going to be, how much discovery you have. It's your initial conference under the federal rules. And we'll get into that in this document that I'm about to put up. And you have discovery that happens later on. Well, what Jakes' attorneys were alleging is they want to subpoena Larry Reed live and Larry Reed because I guess they're trying to figure out who these does are. Okay. For the conspiracy that they have already alleged within their complaints. So they're trying to solidify that there was a conspiracy and that people was just trying to get money and it was all a big old conspiracy to get money out of Jakes. But they need help with this argument. So they want to subpoena and get into the information of Larry Reed live and Larry Reed. Sounded like a bit much to me, but you know, you got to zealously advocate for your client, I guess. So everybody was all over the internet running amok. They about to get all of his records and all of Larry Reed's finances, and they about to do this and do that. And I'm sitting back like, I don't think so. All right. People was in my comments telling me I don't know what I'm talking about. I'm about to see. See, this is what happened when you just don't like people. And so you just want to believe everything that seems like it's adverse against them. You got it. This is why you should always have an open mind, right? Because when you don't like folks, you want to believe whatever negative or bad that can happen. And you try to act like you have on blinders for everything else. All right. But in this thing called the law, even though I don't necessarily agree with a lot of things that are happening in this system, there are rules, all right? Rules that we all have to abide by, whether you're Jakes or whether you Pookie on the corner, okay? And one of those things is you have to have good cause in order to expedite discovery. And you have to have a reason to do so. And so Blackburn responded to that request to expedite the discovery and issue these subpoenas. And they did propose subpoenas attached or whatnot. It wasn't filled out all the way or anything because it was just proposed, because the court would have to give them permission in order to do this at an early stage, because we're not in discovery yet. And so Blackburn responds on behalf of Youngblood and basically said, no, absolutely not. It's no good cause or no reason for us to expedite discovery and not just go through the litigation track that we've been going through. And then proceeded to say, but Your Honor, in the alternative, if you choose to do this, we want reciprocal discovery, because there's some people I think I want to subpoena and depose too. All right. Because allegedly we got some more people that are alleging they were victims. This is all allegation. And that we want to subpoena them too. All right. If this is the case. So then Youngblood goes through a bunch of prongs and all of that. And apparently over there in that jurisdiction, it's just good cause. So then what happened was there was no date. There was a date for Youngblood to respond to this motion to expedite by January 6th, of which they did. There was no date to allow a reply to the response, okay? And so what Jakes' attorneys did was they filed a motion for leave, basically to get permission by the court to reply to the response. But in their motion for leave, they actually put what their reply would be. And basically they were saying that he did it under the wrong prongs. And he also said, they said that Blackburn was not registered over there to be an attorney, to be pro hoc in or to practice there. and there was no indication that he was going to even try to practice. He didn't put like pro hoc vice pending. He didn't put nothing, okay? So after they filed their motion to leave, they being Jakes, Blackburn responded basically with filing his motion to pro hoc vice, okay? Because there were allegations as well that he was not in good standing because of this judge that tried to that said she was forwarding him over to the grievance committee over there in the Southern District and all of this type stuff. And so what Blackburn did was he was like, bam. And he submitted and attached that he was in good standing. That's what he did. And he did his motion right there in order to pro hoc vice. So that was like blow 3. Okay, y'all keeping up? So on this morning, the court entered an order, and I figured something was going to happen today, at least on the pro hoc vice, because it usually doesn't take long. So what happened with Blackburn's pro hoc vice? Let's start with that. So what happened is the court denied his motion of pro hoc vice, but it was without prejudice. And the reason was just more of a procedural issue, of which he's probably correcting right now when he's seen it. So what happens is you have to register to be able to file and all of that under their system. So he did everything. He filed the affidavit. He actually, he paid the fees and all of that, but he did not register under the ECF system. And so the court said, you're going to have to register under the ECF system and basically will, go ahead and redo that. All right. And so it just says that they can file it corrected. And once he fully complies with the rules regarding the admission, the court probably going to grant it. So we'll probably get a granting of that, I assume. Okay, but that's that. But the second thing that happened, okay, I need y'all to hit this like button because we about to get into this document. Let me sip my tea. All right. Y'all got the whole story. So everybody should be up to speed. Even if you knew over here and you just clicked on for the first time, you should know what's going on. I'm sorry, Southwest Houston. I don't know what to do. I posted it on my wall. I put it on Instagram. I don't know what else to do. So yeah. Apostle Dr. Gray said, rules of law, one would do well to know them to win. Very important. And this is one of the reasons why I wasn't being funny. I said that Blackburn, especially if he's going to take these type of cases, I don't care if it's part-time. I don't care if you get a good intern that's all super excited like I used to be before I practiced. You need a good paralegal that can always tell you what the rules are, because rules are very important. And a lot of attorneys, they'll get out. What this is over here. A lot of attorneys, they'll get out of law school and they'll feel like because they are lawyers, they look down on the staff assistants. And I tell you that all the time. If it was not for my paralegal, I would not have went as far as I went. The truth. Because you can lose, and they do teach you that when you do criminal and civil rules of procedures, when you take those classes in law school, you can lose if you don't know procedure and you don't know rules. So having a good paralegal is very, very, very important, or a secretary or an assistant, a legal assistant, whatever title you want to give them, because they'll keep you on track and make sure that you following the rules, the local rules and all of that. So hopefully he does get someone, especially in a case such as this, in order to properly abide by everything. Because what they're going to do, he got big firms. They probably got 2-3 paralegals on one attorney or something. I don't know. These bigger firms, they can afford way more than when you're a boutique firm or you a solo practitioner. And so they are going to look and scrutinize everything that he does. And he is a newer attorney to a degree. He's been like 5 years in. He can probably go be a judge now, because I know here you can be one at 5 years. But for the most part, so just a little bit tidbit from I'm not an old OG, but I'm an OG. That you may that's worth the investment. You know what I'm saying? Thank you, Larry. I appreciate that. Working on me said I have to go back and watch again. I was late. Girl, I didn't get a whole monologue of this whole story. How you gonna be late? I'm just joking. I haven't even been over the paperwork yet. I was catching everybody else, so they knew all the procedures and processes. Because what I watch is how people sensationalize this over here on YouTube. It is not. And then the bad part is they coming for me like I don't do this, and they telling me what's not gonna happen and how it's gonna go and which way it's gonna go and all of that. And even though I've blocked and deleted some of these people, I have screenshot what they said, because I'm gonna hold you to all of this stuff that you said was not gonna happen. And in fact, this right here is one of the things you told me about that you already wrong. This person who I'm not gonna name. But let's pull this document up. Okay. Let's pull up the document. Let me pull it up on here. Oh, what did I name it? Oh shoot, did I even download it? Hold on. I might have got too excited. Oh yeah, I did. Okay, cancel. I don't know why I've been having this problem on here that I have to do it this way, and I don't like doing it this way. But we got to do what we have to do. And so, y'all hit the like button as you come in, okay? It's time to commit, okay? Will there be one? I need you to subscribe to the channel. Will there be one? All right? This is how you stand up there. Will there be one? Will there be one? Does someone want to come subscribe today? Come subscribe to the channel. This is your home. We love on everyone here. Okay? This is your home. All right. I need the ushers. I need the bailiffs. We won't have ushers here. We got bailiffs. I need the bailiffs to pass out the visitor cards for people to come subscribe to the channel and like it. Okay. The like is your donation for the day. The like is your offering. All right. All right. Let's get on with this here. This is the memorandum in order that was filed on today. Okay. And what it says is as follows. This action was initiated in November of 2024. Plaintiff Thomas Dexter Jakes brought claims of libel, which is count 1 against defendant Duane Youngblood, and civil conspiracy count 2 against Youngblood and 10 John Does. Jakes alleges that Youngblood told a patently false story of Jakes' grooming and attempting to actually assault Youngblood during Larry Reid Live online video podcast interviews on October 28, 2023 and November 3rd, 2023. Larry, you stay in print, okay? Goodness. Then, by letter dated November 15, 2024, a lawyer purporting to represent Youngblood demanded that Jakes pay Youngblood $6 million in order to, quote, resolve this matter quickly and privately, end quote. Otherwise, Youngblood would bring a lawsuit against Jakes for sexual assault and harassment. Pending before this court is Jakes' notice of motion for expedited discovery. Jakes claims he knows the identity of the podcaster, Larry Reid, and the podcast company Larry Reid Live, LLC, but that, quote, he requires expedited discovery to further develop the factual matter to properly and appropriately support naming the podcaster and the podcast company as named defendants. And if you want to read that, that's over there filed on the ECF number 15 at page 6. He seeks to begin discovery prior to the Rule 26F conference and issue 2 third-party subpoenas for documents in an effort to verify and identify the Doe defendants. So he wants to get these subpoenas so he can fill out the Doe defendants, is what he's alleging. Briefing is complete on the motion, and for the following reason, it will be denied. I need everyone to hashtag denied, 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 denied. You guys know what to do? Okay. So based on this, it looks like the court also chose not to even consider their motion for leave to file a reply. Looks like that was another, thing that didn't happen here. Okay. That's what it looks like. Okay. While you're hitting denied, hit that like button too. All right, let's go on. Under the federal rules of civil procedures, quote, a party may not, NOT, seek discovery from any source before the parties have conferred as required by the Rule 26F. Okay, and you can find that over at the Federal Rules of Civil Procedures 26D sub 1. The rules allow for discovery prior to a Rule 26F conference, quote, when authorized by court order, end quote. So generally, the general rule is you cannot have discovery until after the meet and confer 26F conference. However, the court does have authority in its discretion to authorize beforehand if they choose to. District courts have broad discretion to manage the discovery process and may expedite or otherwise alter the time and sequence of discovery. So they can control their own court, okay, how they want to do it. That's why, I done sat in front of judges like, Judge, this is a very complicated case. And they're like, okay, counsel, how much time for discovery do you think you need? I'm like, Judge, I need about 9 months, okay? He's like, absolutely not. You tried it, counsel. I'm going to give you 6. Like, okay, Judge, it's your courtroom. I'm just, hey, all you can tell me is no, it's your court. You can do what you want to do. You got the ability to tell me yay or nay. That's what it is. So anyway, let's go on. In that case is that that the court just decided was that in re fine paper antitrust lighting, which is a Third Circuit court in 1982, which says it stands for the proposition that matters of docket control and conduct of discovery are committed to the sound discretion of the district court. While a standard for assessing motions for earlier expedited discovery has not been announced by the U.S. Court of Appeals for the Third Circuit, so there's really even though Blackburn went through these prongs, I guess there's really nothing that I guess they're saying has been announced. There is no precedent on what would be considered for expedited discovery. However, the prevailing approach in this circuit is to apply the good cause or reasonableness standard. So the good cause standard, that is what Jake said was the standard in their motion response. That is what they said, tried to say in their reply that I guess the court decided not to really even consider. But that's what they said was Blackburn didn't use the right standard and that it was good cause. And so the court is also emphasizing that the prevailing approach, although there really is no concrete precedent approach that you have to take, what has been generally used is the good cause reasonableness standard. And that's over there at Robson Forensic Inc. v. Shininski. Okay, and they got some Eastern District of PA opinions. That's the district court opinions over there, and the court has several of those. Okay. The good cause standard requires a district court to, quote, consider the totality of the circumstances to discern whether the need for expedited discovery and consideration of the administration of justice outweighs the prejudice to the responding party. So this is the good cause standard. I'm going to read it again because I need you guys to see why the court said there was no good cause. So the standard the court is going by is the good cause standard requires a district court to consider the totality of the circumstances to discern. So everything that they know to discern whether the need for expedited discovery and consideration of the administration of justice and that it outweighs the prejudice to the responding party. And it has case law. The court holds that Jakes has failed to show that good cause exists for expedited discovery. It recognizes that Jakes seeks to uncover the identities of the Doe defendants. In his complaint, he pleads of the Doe defendants. So this is what he says in the complaint. On information and belief, remember what I told you that meant? I really don't know. I'm speculating. On information and belief, plaintiff alleges that defendant Does 1 through 10, inclusive, are other parties not yet identified who have acted in concert and agreement with Youngblood in order to commit defamatory conduct against plaintiff and have committed acts in furtherance of such wrongdoing. The true names, whether corporate, individual, or otherwise, of those 1 through 10 inclusive are presently not fully known to plaintiff, which therefore sues said defendants by such fictitious names and will seek leave to amend the complaint to show their true names and capacities when same have been ascertained. All right, so that's the reasoning, Let's go on. Let's move on. Within his conspiracy claim, let's get to this conspiracy that everybody keep talking about on these internet streets. Within his conspiracy claim against the Doe defendants, Jakes explains that these defendants, quote, work together to publish and broadcast a false claim that Jakes groomed him and actually assaulted Youngblood on a podcast reaching over 100K persons, knowing that making such false claims on a podcast that reaches such a broad audience of listeners would harm Jakes, end quote. So that is what was said in the conspiracy claim. The most he notes of the alleged conduct of the Doe defendant is that co-conspirator number 1, quote, falsely claimed in sum and substance during the podcast that Jakes had engaged in settlement discussions with Youngblood regarding his claim, end quote. Okay, so the court is saying the alleged conduct of the Doe defendant is that co-conspirator number 1, which would be Larry Reed and Larry Reed Live, falsely claimed in sum and substance during the podcast that Jakes had engaged in settlement discussions with Youngblood regarding his claims. In his brief in support of his motion for expedited discovery, Jakes states that he believes the podcaster Larry Reed had knowledge of Youngblood's plan to obtain money from plaintiff, and he claims, quote, on information and belief, plaintiff submits that there was a plan between and among defendant Youngblood and his co-conspirators, including the podcaster, to share in the anticipated extortion payment once made. So he's alleging that when Blackburn submitted the $6 million demand, that Larry and everybody else was involved, and some other people, not everybody else, but the other John Does who they have named were also involved in trying to get this money out of Jakes. According to Jakes, without expedited discovery, he will be, quote, unreasonably delayed in amending the complaint, end quote, risks iterative conferences with the court once those parties are later added during discovery. And he will face, quote, potentially avoidable disjointed motions initially challenging the complaint, which in turn will likely disrupt the orderly flow of the case management plan in this case, end quote. The court said no third subpoenas will issue. Do y'all hear that? No third subpoenas will issue. It's a no. It's a no for us. It's a no for us. Okay. The bald and vague assertion that other individuals are part of a conspiracy to defame Jakes is simply not sufficient at this juncture to warrant expedited discovery. So basically, you just making, didn't I tell y'all it sounded conclusory? So they're saying this is a bald and vague assertion, just saying that this is what you think, that this is what happened to defame Jakes is just not enough at this juncture to try to get expedited discovery. Jakes has not shown good cause. The court will not exercise its discretion to permit discovery to occur before the Rule 26F conference. There is no immediate need to issue third-party subpoenas, especially the exceedingly broad ones that Jake seeks. And he lets you know, if you try to do these subpoenas, even when discovery happened, this is very broad. Okay? He has failed to put forth viable evidence that destruction of evidence might occur. Because that's the point, is to preserve evidence if there's any evidence that somebody might go try to get rid of it or try to, have a shredding party or something like that. And there's no evidence that anybody get rid of anything, right? Without any concrete evidence of spoliation. And that's what that's called when you try, when you get rid of evidence, or you don't have the destruction of evidence or information. The court will certainly not speculate that evidence was or will be destroyed. Further, the information before the court is such that Jakes has made no articulable showing that the discovery he seeks would actually lead to the identities of the defendants. Not only have you shown there's no information that information will be destroyed, you ain't even showed that what you're seeking will even lead to even identify anybody. And so what people believe, even though discovery is broad, what people believe is once they get in the lawsuits, they can get whatever they want. I'm going to get this. I'm going to get that. I'm going to get your kids' birth certificates. No, there are safeguards. And you can definitely move to quash subpoenas if necessary. You have to at minimum show that it may lead to some. It don't have to be admissible evidence that you're getting to, but it has to lead to some type of relevant evidence that has to do with it. You can't just get into a lawsuit and be like, oh, I've been trying to get information about her mama's car. This ain't got nothing to do with her mama. So why you trying to use this to get her car information? You know what I'm saying? But that's what people believe. I'll just be watching people on the internet like, wow, they really don't know how this thing works. But anyway. So they say there's no information before the court that Jakes has made any articulable showing that the discovery he seeks would actually lead to the identities of those defendants. Notably, Jakes has already admitted that he knows the identity of the podcaster and podcast company. You already know who you're talking about. So if you already know who Larry Reed is, then how do you say I'm trying to use Larry Reed to find other people? I guess that's what he's trying to say. I don't know. Good cause does not exist to permit expedited discovery, and the court will not delve into Youngblood's substantive objections to the discovery Jake seeks. Okay. So what happened is when Youngblood responded, he objected to every single one. And the court just said, I ain't even getting into all that while he's objecting to all the subpoenas. I'm not getting to the substantive of the objections. I'm just denying that he can't do it expedited. Okay. Y'all with me so far? Not that I know of. No, what no quashes, please. Apostle Dr. Gray said, come on, court. I have little faith in courts. I already think they got it right on today. Thank you. Derek Huggins said it was no for the court. That's what Derek said. Larry Reed Live said, I did not, and he said that in capital. So he wanted me to yell it like that. I did not know about the letter until hours before. Hours, maybe 24 to 36 hours before I went, like after Jakes produced the health scare video. So he said he ain't know nothing about it. So he don't even know what y'all talking about. Then he said, I never said what they said. I said a whole lie. Okay. All right. Y'all hitting this like button because that's what I see. I see my mods over here. I'm working hard and my mods is over here begging y'all to hit the like button. That should not be. Okay, let's go on. This is the last part. Oh, I ain't even like turn the page. I'm just reading. Sorry. Sorry, guys. I was just a reading. See, this is why I don't like it on here because then I gotta like change the slides. I don't know. All right, let's go on. The court goes on to say Youngblood has not yet filed an answer or affirmative pleading, and the court finds his attention should be focused on evaluating the merits of the case and not prematurely litigating discovery matters, particularly those seeking information from third parties. So the court said, listen, Youngblood ain't even had a chance to respond. And he needs the chance to focus on responding to the merits of this case instead of worrying about responding to you trying to get discovery. Come on, court. Okay, from third parties at that. Youngblood has informed the court that he, quote, fully anticipates filing a 12B6 motion to dismiss, a likely motion for sanctions, and if necessary, an answer and new matter. So he may do a counter complaint or something to the complaint along with any other appropriate requested relief. According to Youngblood, Jakes, quote, is attempting to use this court as a means to stymie defendants' First Amendment rights and to intimidate a third-party YouTube television show host from reporting on legitimate claims of sexual assault and misconduct perpetrated by plaintiff and other members of the clergy. So the court then quoted Youngblood. Hence, at this juncture, it is unknown if this case will proceed to the discovery stage. So he said, based on what Youngblood is putting out and what he alleges he can prove, you may not even get to discovery at all. Because why? Let me tell you why. Because let's look at the court footnote. The court has the discretion to stay discovery pending resolution of the dispositive motion. So if he chooses to file a motion to dismiss this case, some type of motion to dismiss it, anti-SLAPP, which is new over there in Pennsylvania, the judge can say, okay, we're not doing discovery at all until I decide whether you even have a case, Mr. Jakes, Bishop Jakes. That's pretty much what the court said. And then they put NRA orthopedic bone screw product liability litigation as the case. And that's over there in the Third Circuit, 264 Federal 3rd, page, 344 at page 365, which states that the district court acted within its discretion to stay discovery while considering defendant's motion to dismiss. This is because delaying discovery until a district court has the opportunity to determine whether a plaintiff has pled the necessary facts to proceed with their claims may obviate the discovery process or assist in streamlining the discovery process and minimizes the burden of the parties and the court. So you don't even know if this case is even going to get to discovery. So why are we going to do it in advance? You know what I'm saying? So anyway, Jakes has failed to answer to this court's satisfaction how his need for discovery outweighs the hardship Youngblood would suffer by litigating expedited discovery issues. And now this 15th day of January 2025, it is hereby ordered that the notice of motion for expedited discovery, this case will proceed in the normal fashion and discovery will not commence until after the Rule 26F conference. The court will permit liberal amendments of pleadings pursuant to Federal Rules of Civil Procedure 15 upon timely file motion. That is from the Honorable William S. Stickman the fourth. Okay, let me look William up. Let me look Judge Stickman up. S. Stickman the fourth. Let me see what he talking about. Okay, Stickman. William Stickman. Okay. Let's talk about William Stickman here because he had a lot to say. Thank you so much, Granny the Great, for the super chat. She said, thanks, Pam, for keeping us aware of the shenanigans. Oh, Miss Ken One, you said I'm cutting up. Thank you so much for the super chat. I appreciate that. Let me see if I can pull up, if this will come up on here. Stickman was born in Pittsburgh, Pennsylvania. Let me see what he did. So he was in the office of Reed Smith LLP. He served as a judicial law clerk. Okay, so this is what he did. He was a judicial law clerk for Chief Justice Ralph Cappy at the Pennsylvania Supreme Court. Okay, Judge. Judge Stickman returned to the practice of law as an associate and later a partner of Pittsburgh litigation boutique firm. Okay. In 2011, he was appointed by the Pennsylvania Supreme Court to serve on the Pennsylvania Civil Procedures Rule Committee. Also, he know the rules. Okay, he was a part of the rules. All right. A panel of lawyers and judges charged with aiding the court in reviewing and revising Pennsylvania's rules of civil procedures. The court appointed Judge Stickman to be the chair of the committee in 2015. He is an active legal scholarship. He is the author of peer-reviewed publication on the ancient King's Bench jurisdiction of the Pennsylvania Supreme Court. He served as a frequent guest lecturer on the topic relating to legal procedure and history, and he was served as a judge of the Western District of Pennsylvania on May 13, 2019. He was confirmed by the Senate July 31st of 2019 and received his commission on August 5th, 2019. Let me tell you, he said he did law review articles. I was on law review. Let me tell you. So what happens is when you're on law review, and I didn't know what I was getting into, but they was like, when you're in law school, smart people get on law review. And so I thought I was smart. So I said, shoot, they're going to accept me in here? Okay. So I went on law review, and what they did, let me tell you what my job was. It was the worst job ever, but I got free credit. So it was cool. You know, law school was expensive. But like these judges and stuff, what they do is they'll write articles on, like, say, they feel like there should be a change in search and seizure. So it's like their opinion, weighing all of the different laws, you know, around the country. And they do like a peer-reviewed article on their research because they're considered an expert in the area, right? So you look at it, and we did what my job was, like, whenever you see how in that document it has a lot of citations in it. So it has like case law or whatnot. Well, what my job was is I used to look up the case law and make sure what the judge cited, or it wasn't necessarily judges, but a lot of them were judges. What they cited was actually what it said. So if they put like what he mentioned about having discretion of the court when it comes to discovery, that he has discretion, and then cites a case, I have to look the case up and make sure that the site and the pin site, which is the specific page that it's on, that it actually matches up to what they said. And sometimes you would get people, these legal scholars, because I think they knew we was helping them out for free. They would basically like only put a case. Like they'll put Smith v. Walmart. It's probably 1,000 Smith v. Walmarts. And sometimes you would literally have to look up those cases and try to figure out which Smith v. Walmart they're talking about. And then find the pin site and find the actual citations. When I did it for like, I think I had to commit to 2 semesters. It's a good resume booster now. When I was out here and I would tell people like, yeah, I was on law review, You know, that boost you up, your credibility. But every time I had to look at some of that work and how they would half do it, or some of these legal scholars would like half put the information in there, or it didn't say what they said it said. So I almost had to go find a case that said what they said it said, and all of that stuff that I did. I'd be like, why did I do this? Why did I even get in there? Why did I give myself extra stuff to do? I was already working full time all through law school. Like, why did I do this to myself? But yeah, that's my law school story. I don't ever like my law review. I don't ever tell people I was on law review either. I probably should have put that on my website. But yeah, that's like when a lot of these people, a lot of these, you know, judges, or like I said, legal scholars, they'll do these type of papers and all of that stuff. So anyways, I digress. Hello to my favorite and most knowledgeable YouTube attorney. Happy New Year. Thank you so much, number 12 online. Thank you. You know what, Aunt Nettie, I'm not. Thank you for the super chat. I'm not going to see. He already suing people for that. So y'all know Jakes is over there suing people in California for all them AIs, as he should, because some of that stuff is ridiculous. Absolutely ridiculous. So anyway, this looked like another no on the Jake side. And so we'll see what happens. So how it is scheduled now on the 23rd. So we have, what's the day? The 15th. We have 8 days before. So approximately a week before Youngblood is supposed to respond to the complaint. And he is alleging that he is going to file a motion to dismiss. He is alleging they had affidavits, or they going to get affidavits, or whatever they plan on doing to attack. So it should be a very interesting response. So the bottom line for those of you that just came in is that the judge was like, no, won't be no expedited discovery to try to figure out who alleged conspirators might be. And so that's that. That is the order of the court. Angelique said the court was not playing. Thank you for the super chat. No, they just follow the rules. Like, if you got to have good cause to say, I know who the podcaster's name is. However, he may lead me to other people on this theory that I have in my head without really having really legitimate proof, allegedly, because I didn't see no proof really in there. It was conclusory. It was a bald-faced assertion, basically, as the court said, that this was even a group effort to try to get this money. And I'm trying to basically find some way to confirm what my suspicions are. I don't know. So yeah, that's it. That's all I got, y'all. You guys have any questions? Thank you guys so much for spending your lunchtime with me. You know, I appreciate the time that you guys have. You said you wow, I caught noonday court. Hello, Your Honor and intellects. I would be an interesting judge. I don't know. I like to litigate too much though. I don't know if that would be somewhere in my future, because I actually like the game. Like, I like to get in there and go to the mat. That's what I like to do. Thank you all for the 600 likes. I appreciate that. I have begged you enough. I should. No, thank you so much. And again, if anyone would like to make this Sunday, I want everyone to close their eyes. And I want you to just hold up one finger. I see you. I see you over there in the back. I see you up front. I see you over by the door. It's okay. Everyone, keep your eyes closed. Now, all of you guys that I saw, I need you guys to hit the subscribe button before we get out of here, okay? And make sure you hit the like button. All right. Thank you guys again for your time, your consideration. Again, Youngblood said he was just telling his story. Jake said his story was a lie. That is what we are dealing with on today. The court said there will be no expedited discovery. You can, especially with a third party subpoena. And in fact, your subpoenas were overly broad. You have to narrow that down. You have no indication that before you try to subpoena this man's and his company's stuff, that you even gonna find what you looking for. That's what he said. So with that, I want you all to have a great day. Take care of each other. No, what did Jerry Springer say? Take care of yourself and each other. Is that what he said? Take care of yourself and each other. It's been fun, but I gotta run. You're cute, but you gotta get the boot.